Hi everyone, and welcome to the first event for Clause 40 Foundation's Conversations on Emerging Scholarship in Criminal Law and Policy. My name is Shannon O'Toole, and I am the founder and president of Clause 40 Foundation. Today's event is a dialogue between two brilliant women. First, here on our right, or on our left, is Carolyn Iodice, who serves as senior counsel at Clause 40 Foundation. When I first met Carolyn through her work on the Hill, she was serving as a longtime legislative director for Representative Justin Amash, and I was so impressed with her that I thought to myself, this is exactly the kind of person I hope wants to come work for the foundation and focus on these kinds of things from the other side, from a different lens, when she's ready to leave the Hill. And we are thrilled to welcome her, and she just joined us on staff this summer, and we're very grateful to have her. On our right, we have Professor Carissa Byrne Hessick, the author of the book we are featuring today, Punishment Without Trial, Why Plea Bargaining is a Bad Deal. This is a great title. Carissa is currently the Ransdell Distinguished Professor of Law at the University of North Carolina School of Law. She also directs the Prosecutors and Politics Project, which she founded in 2018, and she began her career as a litigation associate in New York City. So she knows what she's talking about. Carissa's book, Punishment Without Trial, was officially launched just yesterday, and so we are very humbled to have it serve as the subject of the very first of our series. If you enjoy our event today, we hope you attend our other events, which are coming up in the future. Stay tuned for announcements about upcoming authors and upcoming books. But we are particularly thrilled to have Professor Hessick here today because her book fits seamlessly with the mission of Clause 40 Foundation. I founded this organization and its sister organization, Due Process Institute, as nonprofits dedicated to preserving and restoring our constitutional due process rights. As part of that mission, Clause 40 Foundation specifically works to educate the general public on the erosion of our due process rights and how our rights are being currently undermined in our criminal legal system. In Punishment Without Trial, Professor Hessick describes this crisis, and unlike some law professors, she does so in a way that is very accessible and it's enjoyable to read, even for people who consider themselves well outside the worlds of policy and of law. Her book is appealing, it's a good and quick read, and importantly, it meaningfully illustrates a particular and very unique problem in our nation. How an almost complete lack of criminal law trials, where the government's case against a person can be challenged or put to the test, how that is contributing to the erosion of due process rights for all of us, regardless of whether we are ever charged with a crime. And with that, I'll turn it over to Carolyn to guide us through a conversation with Carissa about this problem and its solutions. Thank you for joining us.
All right, thank you, Shanna, for that kind introduction. And thank you, Professor Hessick, for being with us for today. As Shanna mentioned, your book explains what is really a very complex legal and policy crisis, but it does so in ways that can be understood by people who don't have a JD or haven't spent time in public policy. And in that spirit, what I want to do is just start off with a little bit of some basic terminology so that we're kind of all on the same page as we get the discussion going. So first, can you explain briefly what is plea bargaining, and then within that, what is charge bargaining?
Definitely. So thank you so much for having me. I'm excited to be here today. Plea bargaining, to understand what plea bargaining is, it probably makes sense to think about what happens at the beginning of a criminal case, right? So if somebody's been charged with a crime, one of the first things that they're asked is, how do you plead? Do you plead guilty or not guilty? Person pleads not guilty. That means they're not admitting that they committed the crime and they want some sort of process to happen. If they plead guilty, then it goes right to the punishment stage of the criminal case. A conviction will be entered against them. Plea bargaining has to do with that idea of pleading guilty, but not just pleading guilty because that's sort of the decision that the defendant made. It's a negotiation process between the defendant and the prosecution, where the prosecution agrees to certain things in return for the defendant pleading guilty. So, for example, the prosecutor might agree to make a lenient sentencing recommendation to the judge to say, hey, don't give the maximum sentence, give the minimum sentence, that would be the best thing to do in this case. That could be the result of plea bargaining. Charge bargaining is a particular type of plea bargaining where instead of just making a recommendation to the judge about what ought to happen, the prosecutor actually makes a decision about what the defendant should plead guilty to. So the prosecutor might say, look, you committed this crime and we charged you with having violated 5 different criminal laws. You only have to plead guilty to 1. Or they might say, you stole something worth $10,000, but we'll let you plead to petty larceny, which is stealing something worth less than $1,000 in return for you pleading guilty. So charge bargaining means the defendant, what crime the defendant pleads guilty to, that's the piece of negotiation between the defendant and the prosecutor.
So you mentioned that often what the prosecutor will be asking or will be offering is a sentencing recommendation. Do judges have to take that recommendation, or does it just influence what their decision will ultimately be?
It depends on which court you're in. Some courts actually allow the defendant and the prosecutor to enter into a contract where the defendant says, I'll plead guilty so long as I get this sentence, and then the judge gets to choose. If the judge agrees to impose that sentence, the judge will accept the guilty plea of the defendant. But if the judge doesn't want to give that sentence, the judge will say, no, I reject this plea. We don't have great data on this, but the data we do have suggests that judges almost always accept those contracts, which binds them to give a particular sentence.
Okay. So now we know what plea bargaining is, and your book makes the point that we have moved into a system where we're mostly resolving criminal cases through guilty pleas. But that wasn't all. And so I'm curious what specifically the rates of jury trials versus guilty pleas are nowadays, and then how that compares to SART.
Yes, you're asking a great question, one that I should have the answer to, but unfortunately I don't. What I do know is what the rate is in federal criminal cases and what the rates are in about 22 or 23 states. So if you look at that data, we know that fewer than 3% of defendants who are convicted had a trial. The other 97 point whatever percent, they pleaded guilty, most of them as part of a plea bargain. So as you might imagine, because we actually just don't do a very good job keeping track of what happens in our court systems, which is distressing and something we should definitely talk about. But because it's so difficult to find out what's going on now, it's even more difficult to find out what used to happen. We have very little information back at the beginning of when sort of this country first started. We do know that in England, defendants were discouraged from pleading guilty. They would come in and say, I did it, and the judge would say, whoa, 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 let's have your trial. They would ask, did somebody pressure you to say that? Like, let's hear from the witnesses. At some point, judges stopped discouraging defendants from doing that. We don't know when exactly because we don't have good court records. We do know that soon after the Constitution was adopted, there was some plea bargaining that happened in a couple of courthouses in Massachusetts. We only know that because they kept good records of their documents, and some scholars went and sat in those archives and went through it. But even then, the guilty plea rates looked really different depending on the types of cases. So if they had like alcohol cases, they tended to have plea bargains, but other cases they really didn't. There's another sort of historical study from Los Angeles around the turn of the 20th century where they say it looks as though about half or 60% of defendants were pleading guilty. And then in the federal system, we have some good information, but for a long time, there weren't that many federal crimes that were prosecuted. We do know that around the 1970s, which is the first time that the US Supreme Court said that plea bargaining was constitutional, still about 20% of defendants were going to trial. So we've seen some dramatic decreases in the past few decades, and even just in the past decade or so, the trial rates shrunk even further. It was, there were only about 95% of defendants pleading guilty. Now we're up to about 97%.
So, your book, I understand a lot of the concern about just the sort of loss of the trial, which is illustrated by those statistics. Is it the factors that have led to 97% of cases being pled out are also leading innocent people to plead guilty? You have a number of anecdotes in your book of people confessing and pleading to crimes that they didn't do, and it's not petty crimes, it's rape and murder and crimes that would get people sent away for a very long time. And so for folks outside the system, that may seem irrational. Why would you say that you did something you didn't do and put yourself at risk for potentially life in prison, if instead of going to trial and possibly being exonerated? So what are some of those factors that lead innocent people to plead guilty?
Yeah, it's a great question, and the factors look different for different people. You asked specifically about the people who plead guilty to serious crime, like Damian Mills, the man in Western North Carolina who I interviewed at the beginning of the book. He pleaded guilty to a murder that he didn't commit. From his perspective, it would have been irrational for him to have insisted on going to trial, because defendants have to try to figure out how likely it is that they'll be convicted at trial. And for a long time, even before plea bargaining came into fashion, defendants who insisted on going to trial would get much, much longer sentences from judges if they wouldn't plead guilty, if they'd insist on taking up the time of the court and the time of the prosecutors and making witnesses show up to court. There's a recent study by the National Association of Criminal Defense Lawyers, just using federal data, because data is so hard to find, showing that on average, a federal criminal defendant spent 3 times as long in prison if they insisted on going to trial than if they insisted on pleading guilty. So why does that matter for the innocent defendant? Well, the innocent defendant has to try to figure out what's the best course of action for me. So I'm gonna, you'll have to forgive me, we do a little bit of math. Not too much, not too much. So imagine that you've been accused of a crime that carries a 10-year sentence in prison. You're innocent, but you think that there must be at least some evidence suggesting you're guilty, because otherwise the police wouldn't have arrested you and the prosecutor wouldn't have filed the charges. So let's say you estimate your chances of getting convicted at trial are 20%. If the prosecutor gives you a plea bargain where you spend only a year in jail, you'd be silly not to take that deal, because your expected punishment is 20% of a 10-year sentence. It's 2 years, right? It's like, this is the math, the expected punishment. It's like, do you guys have those friends who they're like, it actually makes economic sense to buy a lottery ticket right now? You know those people? And I'm always like, all right, maybe it does, whatever. It's because the value of the lottery ticket has to do with how big the pot is and your chances when, I know it's super annoying, but I'm hoping the 10-year sentence one is easy to understand more so than the lottery tickets. If you didn't take that 1-year deal, you'd be acting irrationally. There's actually a story in the book about a gentleman from upstate New York who was accused and convicted of growing a whole bunch of marijuana on his farm with his dad. And his defense attorney and the prosecutor kept ordering, and the judge, frankly in this case, kept ordering competency evaluations because he was refusing to plead guilty and the evidence against him was overwhelming. They assumed he literally must be crazy because he's refusing to plead guilty because the deal was too good to pass up. So in some ways, it's a little bit ironic, right? When we talk about plea bargaining, people often want to talk about how defendants get pressured into taking very harsh plea deals, and that's true. But the reason why plea deals can be so attractive, it's because the alternative is so awful. And so if the plea deal is better than the expected outcome of trial, it actually makes sense for the innocent person to accept it. So when I talked to Damon Mills and I asked him, I said, do you regret pleading guilty? He said no. He assumed he would have been convicted. He was a black man who'd been in trouble before. The police had convinced the man's son who'd been murdered to say that he recognized some of the people who were there. He thought he'd be convicted. His only regret is that he didn't negotiate a better plea deal for himself, to pleading guilty to the murder he didn't commit.
Mm-hmm. So sentencing, it sounds like, is a big factor. Just reducing your possible exposure if you were to go to trial. What role does pretrial incarceration, which also plays a big role in your book, what role does it play in that calculus as well for innocent and guilty, but especially for innocent people?
It plays a huge role, and this comes into play more in the less serious cases where people might not necessarily get a jail sentence at all if they're convicted, but they're being held pre-trial because they've been arrested. In those situations, if they can't afford the bail to go home, or if because they might be ineligible for bail because they have previous convictions, if they plead guilty, they can go home right away. And I'd like to say that if I were innocent of a crime, I'd insist on proving that in court. But the truth is, if I had to say that I'd done something I didn't, and the difference was living in a jail or living back in my house, I think I'd probably go home as soon as I could. And this is, part of this is a function of the fact that American jails are terrible places. They're violent. You get COVID there. You can be murdered by other inmates. You can be subject to terrible abuse from the guards. The food is terrible. The living conditions are inhumane. And that doesn't even mention the fact that, or that doesn't even start to get at the idea that if people are in jail, they're probably going to lose their job. A lot of them might lose their children. They might end up living on the streets. So the pressure for them to plead guilty rather than insist on a trial is pretty overwhelming. And it's to be expected. We're keeping people in prison. We're telling them it's not punishment. And yet, if they plead guilty, their sentence will be to time served. So we magically sort of transform the preventative detention that's not punishment because they haven't been convicted to punishment on the back end. The studies that have been conducted in cities that look very specifically at people who plead guilty for these low-level offenses show that whether somebody is ordered detained or not, or whether they're able to afford bail, makes them much more likely to plead guilty.
So some of it is just the fact of being incarcerated keeps you away from your job and your family, and then some of it is prison conditions and jail conditions are horrifying, and you want to get out as soon as possible.
But you know what's kind of crazy, Carolyn? Even the people who do get out, a lot of them end up pleading guilty anyways because of how we treat them when they're out and they insist on wanting to go to trial. So I was out at a law professor conference, which sounds like more fun than you might think, talking to a guy who teaches at one of the schools in Maryland, and he was telling stories about when he was a public defender in the Bronx. And he told this story that's like something out of, I don't know, like a dystopian novel about a kid who was in his own apartment building in the Bronx and who got arrested for trespassing. Obviously, you can't trespass in your own building, like he lives there, but he had his wallet upstairs in his apartment, and the cops said to him, well, you can have someone get their wallet when they come to bail you out. So the kid spends the night in jail. The next morning, he meets with my friend, David. And David says to him, okay, we're gonna show up in front of the judge. The only thing you can do right here is either plead guilty or not guilty. If you say you're not guilty, the judge will make a decision about bail. You'll get out. You don't, right? This isn't a serious crime. You don't have any previous arrests on your record. The judge is just going to say you can probably leave on your own. Don't worry about it. And then what we'll do is the next time you have a court date, just make sure to bring your wallet. It'll have your ID in it with your address, and then we can get these charges dismissed. And his client was like, "That's okay. I'll just plead guilty." And David's like, I'm sorry, you said you live there. And he's like, I do live there. He's like, but I already missed work today. I don't want to miss work to have this happen again. it's going to be a fine of $100 if I plead guilty to this. They were not going to actually make him plead guilty to trespassing. They're going to make him plead guilty to disorderly conduct, which is a $100 ticket. And the guy said, it doesn't make any sense. I'm going to lose more than $100 if I lose that day of work. I might as well just pay the ticket and go home. Because we insist that people have to keep showing up to trial. Even people who aren't going to be able to, just show their ID and say, see, I didn't commit the crime. They get forced to come back again and again and again as court dates are postponed. Prosecutors say, oh, we still don't have all of the discovery in this case, and then they'll set a new court date, a couple months out. Every single time that the person has to come back to court, that's money that they're not making, time they have to take off from work. They could get fired for that. They might need to arrange for childcare, pay for parking or the subway to get there. And the whole time that that's happening, if they end up getting arrested again, there'll be an outstanding charge on their record, and then they won't be given bail. So David mentioned that a number of people that he was representing, they'd get arrested. The cops in New York were doing these sweeps of buildings, and they kept arresting people for trespassing. If you were out on one of the charges trying to get it cleared up and you got arrested again, they would just keep you in jail, and then you plead guilty to go home. So it's the system itself actually imposes these costs on people that'll make them say it's not worth trying to get the case resolved. I'm better off if I just plead guilty.
So that's sort of, we mostly focused on people who are innocent of what they've been accused of. But in practice, most people who are convicted are factually guilty. They've done either what they're accused of or they've done something illegal. But you make the point in your book that we should still care about when those people plead guilty at enormously high rates. Why is that? Why do we care when someone is it more efficient for guilty people to just plead out and then we can move on?
Yeah. So first of all, I'll just say I'm not confident how many people plead guilty are guilty because, it's easy when we think about crime to think about serious felonies like robbery or kidnapping or arson or those sorts of things. There are only 1 million of those cases every year, and there are 13 million misdemeanors, which are the trespassing and, trespassing or disorderly conduct, or one case that I liked where a guy got into a fight with a cop who was off duty and who screamed profanity at him and got arrested for disorderly conduct and assaulting a police officer. The guys were shouting at each other at a public swimming pool. Was it disorderly conduct? Maybe under the text of the statute, but the cop was shouting at him too. This guy just wasn't able to arrest him. But those cases, there's no DNA evidence to exonerate them. And by the way, if you plead guilty, you actually usually don't have the process available to you in most states to try to clear your name afterwards. But let's still talk about guilty people, because I agree with you. There are plenty of people who commit crimes and who then plead guilty. Why should we care about that? Well, I think it depends. It depends on, first of all, we should care, but why? Well, if you care about defendants themselves, you should care about the fact that they're getting pressured to give up their rights. That's not something we generally let the government do. If I were on my way to go vote and a police officer stopped me and said, if you vote today, we're gonna make you pay $150 or we're gonna keep you in jail overnight, the Supreme Court would be like, yeah, no, that's totally unconstitutional. But for some reason, they've decided that those rules aren't going to apply when it comes to plea bargaining. It's totally fine to say, if you invoke your right to a jury trial, then we can keep you in jail for longer. So the idea that we're pressuring people into giving up their rights, that's bad. It's also bad because sometimes people are pressured to give up other rights as well in plea bargaining. So somebody who, when they're arrested by the police, for example, end up getting beaten, and they'd be able to win a civil rights suit for that sort of police violence. Or maybe the police kicked down their door and caused property damage, or didn't have a warrant for the search, or any of those sorts of things. The government uses those as bargaining chips in plea bargaining in a way that a lot of people think incentivizes, or at least doesn't discourage police officers from engaging in that sort of behavior going forward.
Do people give up the right to challenge those actions in what would be their criminal trial, or do they give up their civil right to?
Both. Oh yeah, you're allowed to put anything in that plea bargain. In fact, sometimes people will plea bargain over whether the government will charge their kids or their spouse or anything like that. The Supreme Court has said it's an open negotiation, right? The defense and the prosecutor are free to bargain over anything that they want to and put it in that contract. So yeah, they give up their civil claims as well as their ability to challenge it in the criminal case. But look, I'm under no illusions about how a lot of people probably think about those who've committed crimes. Some people are just like, look, you shouldn't commit a crime, and that's just sort of where I come down. So I think it's also worth thinking about what the costs and the harms are to other people when we have plea bargaining. Victims, for example, plea bargaining can be really, really disrespectful and harmful to victims. The charge bargaining that I mentioned earlier means that a lot of times when you have a plea bargain, you have a defendant pleading guilty to something that's far less serious than what they're accused of doing. And from the victim's perspective, that can be incredibly, just so disappointing and disheartening. One of the things that I talk about in the book are a bunch of cases in Ohio, rape cases, sexual assault cases, where the defendants were being allowed to plead guilty to a certain type of assault, where it's not just like I sort of came over and I punched you, but I did that only after you had started an argument with me. So it's a lesser charge because the victim is somewhat at fault. I don't know how anyone could ever think that that sort of charge could be appropriate in a rape or a sexual assault case. And the message that those sorts of plea bargains send to victims is really horrible. And a lot of victims end up feeling as though they were supposed to get their day in court, where they had a chance to tell their story. And even if they didn't want their day in court, I think a lot of them don't want to see defendants pleading guilty to really sort of small, menial crimes that they didn't commit. And then I'd say, from our perspective, just as like citizens in the United States, we're supposed to sit on juries because we're supposed to make these decisions, and we're supposed to act as oversight, as checks on government officials. We want to make sure that the government actually has good evidence here. We want to make sure that they're actually bringing appropriate charges against defendants, and if they seem like they're overreaching, then we should, acquit or maybe nullify. We get cut out of the process altogether, and it's not just that we don't serve that role of acting as a check in individual cases, it's that we literally don't know what's going on. It's incredibly difficult to find out, even if you're motivated to find out, what's happening in your name. Most of us don't know the names of our elected prosecutors, let alone what their plea bargaining policies are. I study prosecutors for a living, and I don't know what the plea policy is for sexual assault in my county because that sort of information isn't made available. And if you ask for it, they'll tell you no.
Is it written down, or is it like a informal policy?
It depends. Even when it is written down, you don't have a right to get access to that. There was a couple of groups sued DOJ trying to get a hold of a manual where they advise the federal prosecutors across the country about what to do with certain things, and they were told that that's confidential information that the public shouldn't have access to.
I want to, you mentioned the word nullify.
Mm-hmm.
Can you explain briefly jury nullification?
Yeah. Jury nullification is, it's very controversial, but the idea is basically that we have, our modern understanding of the jury is different from what the framers intended, right? The people who wrote the Constitution, they saw the jury as a protection, a way to protect individual rights in particular cases. There's some great letters from Thomas Jefferson and John Adams talking about if they had to choose between whether people should have the right to vote for their members in Congress or the right to serve on juries, that they would choose the right to serve on juries because justice is so important in individual cases. That's not really how we talk about juries nowadays. We talk about juries just as serving the function of deciding when there's disagreement about the facts. So I say you held up the liquor store, you say you were in Poughkeepsie that night with friends, I call some eyewitnesses, you call some eyewitnesses, and the jury has to decide who they believe. That's how we talk about juries nowadays. But the truth is, juries didn't used to just make decisions about facts, they used to make decisions about law as well. We say now that the judge is supposed to make all of those decisions, but if you read the old sort of transcripts from these cases, judges actually used to give the juries their own thoughts on the law and the facts, and then it was up to the jury to make these sorts of decisions. So juries were empowered to nullify, was sometimes called acquitting against the weight of the evidence, where they basically say like, yeah, I mean, she probably did it, but it doesn't seem right to convict her here. And in fact, some of the modern day legal rules that we have, like the provocation defense, we only have them because courts realized that there were certain circumstances under which juries were like, it's inappropriate to convict people. And so we actually built up these criminal defenses because of the feedback we were getting from juries in specific cases. That's not what we do anymore. Nowadays, if a jury fails to convict and it seems like the evidence was really on the side of the prosecution, we say that they were lawless or that they nullified. And the US Supreme Court has said that jury nullification is wrong, but there's nothing they can do to prevent it because we can't actually sort of look inside the minds of jurors to figure out whether they thought the defendant was guilty, but they were acquitting because they disagreed with what the prosecutor did in that case or that the punishment would be too much. They say they can't sort of get inside the minds of jurors, but they still say it's inappropriate. And so because of that, lawyers can't make arguments to juries that they should acquit. They can't even make arguments to juries, by the way, if you convict, here's what the sentence will be, so that the jury will try to make up their minds. But it's still pretty clear that at least some jurors take that, still use their power to nullify. Mm-hmm. Which I should add, how you feel about jury nullification might depend on the case at hand. If you agree that that person probably shouldn't go to jail, then maybe jury nullification seems like a good thing. But I mean, if you look at the Jim Crow South, when people who would attack or kill African Americans were consistently being acquitted by all white juries, then you could say jury nullification is a bad thing. I think what we really need to think about when we're talking about the criminal justice system is we shouldn't just care about the procedures that are in place. We shouldn't just care about efficiency. We should understand that at bottom, this is a messy system that's designed to make moral judgments about people, and we need to be able to talk about those moral judgments as moral judgments. That's really what we should do more of.
So your discussion of both the good and the bad of juries is a perfect segue into what I want to talk about next, which is, so you decry the rise in pleas, and you prefer a system of trials, or at least a system of more trials. But trials are imperfect. Jurors can be racist and biased in other ways. They can be capricious, irrational. Trials can exacerbate wealth inequalities because if you can buy better representation, that's going to go farther in a trial than if you're just negotiating a plea. And then as you pointed out, as I say, the process is the punishment. Being a defendant in a criminal trial is not fun. It takes a ton of time. It's inconvenient. Do any of these criticisms of the trial, do you think, undermine your complaints about the plea system?
I don't think so. I mean, to be clear, I think it's unfortunate and wrong that the system that we have now, the default is plea bargaining. everything's being funneled towards pleas. The expectation of attorneys is that there will be a plea bargain. The expectation of legislatures when they write these laws and set these punishments is that they'll be plea bargained around. So I think that plea bargaining as the default is a real problem, and more trials could be part of the solution. But it's also true that trials are deeply, deeply imperfect. They obviously come to the wrong conclusions in at least some cases, and we should do more to try to reform the trial system. I think what we've done is we've given up on that project and said we're going to replace it with plea bargaining. But unfortunately, plea bargaining doesn't get rid of any of the problems that you just identified, whether it's wealth inequality or racism or bias. Those things live on in the plea bargaining system as well. The social science studies about sort of racial bias in decision making don't show that people with legal training have less bias than ordinary Americans who sit on juries. So just because these decisions are being made by prosecutors and judges doesn't mean that poor people or people of color are getting a better shake than they would if they went to trial. And in fact, when it comes to things like the inability to post bail, wealth inequality is baked into the system even more so. Or having a good lawyer who might get you acquitted at trial turns into having a good lawyer who has a great working relationship with the district attorney and who's probably been a political donor of the elected district attorney as well. So in some ways, all of the problems that we see with trial are just sort of magnified and seem more corrupt than they do once we look at them within the plea bargaining system.
All right. So you've talked at length about plea bargaining in general, and to lead us into our final topic, I want to talk about sort of what it looks like in practice. You mentioned in a section about observations of how pleas work that often defense attorneys and prosecutors will negotiate pleas without having carefully studied the actual case file, like looking at who the defendant is, what the allegations are, what the evidence is. They may or may not have actually familiarized themselves deeply with that. And then you also talk about this phenomenon of bargaining across cases. Can you explain what that is?
Sure. So there was a study of the New Haven court system that was done back in the 1960s by a social scientist turned law professor who decided he was going to spend a year, who must have had a fellowship at Yale because why else would you pick New Haven, Connecticut? He was going to spend a year sitting in a courtroom in New Haven studying trials. And then there were no trials the whole year. This is back in the 1960s. And so instead, he ended up studying the courtroom dynamics, and he was the first person who came up with this idea of the process is the punishment. But he had great access. He spent a lot of time talking to the prosecutors who were appointed in New Haven and the and the defense attorneys who came through the courtrooms. And he observed quite a lot of things, including a defense attorney having conversations with prosecutors where the deal that they were going to work out in this particular misdemeanor case depended on the previous deals that had been struck that day. And not in the sort of like, let's try to be consistent, that guy did the same thing and we gave him this deal, let's give the same deal here. It was instead the prosecutor saying, I can't give this to you, I already gave you a good deal for that other guy, my supervisor is going to give me a hard time if I go back with too many of these. Or the defense attorney saying, look, you haven't given me a good deal yet today, cut this guy a break. Once we have a system that runs on where efficiency and disposing of cases quickly and cheaply becomes one of the primary goals, that sort of stuff seems acceptable, as opposed to seeming like, oh my goodness, what are you doing? These cases have nothing to do with one another. These are individual people. You shouldn't horse trade over people's liberty and lives. It feels arbitrary in a way that's deeply unsettling. But if you're going to say that efficiency is what matters most, then all of a sudden things like moral judgments about what people did seem a lot less important. This is actually, you'll have to forgive like the minor rants. This is really bothering me right now, because right now in this country, we probably have the most attention that we've ever had focused on plea bargaining. And that's because of the January 6th cases, right? More than 600 people have been charged with storming the Capitol on January 6th. And so we have almost like a natural experiment in plea bargaining. And as of just earlier this week, 100 of them have pleaded guilty. You get a glimpse into how DOJ, because these are all federal cases, is dealing with these cases because they have to deal with so many at once, and because the media and the public are paying attention. And we've seen some headlines because judges are asking some pointed questions in these cases. And one of the questions that keeps coming up is whether it's appropriate to have a bunch of the people who didn't fight with police or who didn't, damage things or break into Nancy Pelosi's office or what have you, or plan things beforehand or bring out weapons. The people who just went in, walked around, and left, how to treat those people. Because the truth is, those people, because of the really sort of huge criminal codes that we have, those people committed some pretty serious felonies. But most of them are being allowed to plead guilty to a misdemeanor that's basically like different types of disorder on Capitol grounds. The one that they're getting is the demonstrating, picketing, or parading in the Capitol illegally. And some of the judges are asking questions. Is this an appropriate charge? And the prosecutors are saying, when people plead guilty early, it's the government's policy to give them a good deal. Their answer is efficiency is our guiding decision-making principle. I have to say, that should be dissatisfying to all of us. By the way, I don't know that those people should be convicted of a felony or spend years in prison for what they did. I mean, our criminal laws are too harsh. It's just the laws on the book are written in a way that's too harsh. But the people who are charged with making these decisions, right, who get to decide what criminal charges to bring and get to decide what sort of plea bargains to offer, they should have an answer for the decisions that they make that's better than this makes our jobs easier. None of us should be satisfied with that answer, but when we say we should have plea bargaining because it's efficient, we're signing off on that sort of moral judgment, and I actually think none of us agree with that.
Well, it suggests a system that is not terribly concerned with adjudicating individual guilt and innocence and what is a just outcome in this particular case. Rather, it suggests that we just need to process in jail some vaguely defined groups of people, and we're not hugely worried about who those people are specifically.
I want to give DOJ a little bit of credit, not too much, but a little bit of credit, because I do think that they're trying to divide people into categories. They have the people who didn't scuffle with police. They don't have any evidence suggesting that they planned to storm the Capitol beforehand. They're not part of the Oath Keepers or any of these other groups that seem a little scary, more than a little scary. They've divided those people off and decided to give them the misdemeanor pleas. They've had a few people who did scuffle with police or assault police plead guilty, and they've made them plead guilty to the felonies. Not all of the felonies they could have brought, but some felonies. So they are trying to break them into groups. They're pretending as though they're not necessarily, right? They're talking about efficiency. What they're not doing is defending the judgment that they made on the merits. And then I'd add, they could probably make some finer distinctions within that group of the people who are getting the misdemeanors. The woman who filmed herself walking out of the Capitol saying that they showed up to shoot Nancy Pelosi in the head, but she wasn't there. I don't know that I feel super comfortable with her pleading guilty to a misdemeanor. DOJ had to make that decision. They should explain it. So it's not that they're failing to make these individualized decisions, it's that they're pretending as though they aren't. They're hiding behind the veil of efficiency. This sort of, it sounds very objective and neutral to frame it those ways. In fact, I keep saying moral judgments, and I'm sure some of you guys are cringing inside, and you're like, oh, moral judgments, don't we all disagree about moral judgment? Yeah, we do. But there's no getting away from the fact that criminal law is all about moral judgments. That's why we put people in jail if they kill people, but not if they were acting in self-defense, even though somebody died. We make these moral judgments all the time. And saying efficiency doesn't mean they're not moral judgments. It either means we're refusing to look at them as moral judgments, or we're refusing to have the conversation about whether we can agree about what those judgments should look like.
Right. And so so there's the Capitol rioters, which is a nice little case study. But with respect to the New Haven court system, if you're bargaining across cases, it's like whether you got a good deal for one client earlier in the day is as relevant to the case at hand as like what the weather is that day. Like it's totally irrelevant.
I agree with you.
Yeah.
That's not a moral judgment. That's arbitrariness. That is literally like it's treating people differently for a reason that can't be justified, not on its face. It's probably people who've spent too long in those courtrooms doing those jobs that they think it's okay to say those things at all, let alone in front of a sociologist.
All right, well, on that happy note, I'm going to turn it over to the audience for some Q&A. Anybody have any questions?
I'll ask one. So I was a public defender, and I guess my question is, do you have any data to show if there's strategic charging decisions, do things like leverage, get bail set, and then coerce people into pleading guilty? Because I know this would come up a lot with people that would be trespassing an establishment, break in, steal, or not even break in, they just go into Walmart, if you trespass and steal something, they're charged with a felony, and then if they have 3 priors, they can get 30 years in prison. Is that, so those cases would bleed out immediately so that they don't, if we go to trial, they'll have to get years in prison. So do you have some knowledge about, if there's strategic charging decisions used to basically coerce people into pleading guilty?
Oh, so yes. So we don't have good data about it, right? Because it's so difficult to gather that information. And in fact, what's more likely to happen, right, is that the person's arrested and then they're threatened with the 30-year charge. It's not brought in the first instance. They plead guilty to what they're charged with, but if they won't plead guilty, then the higher charge is brought in.
Right.
It's interesting, the Supreme Court case where the justices signed off on that one, that sort of leverage, the threats. It involved exactly what you're talking about. It was a recidivism law from the state of Kentucky. And one of the justices was trying to make the argument that if only they'd brought the more serious charges initially and then offered to drop them, that would be permitted. The real problem was that they were threatening to bring these charges and only brought them afterwards. And some of the other justices are like, that's a distinction without a difference. Why should it matter? And I mean, maybe from a due process standpoint, it shouldn't matter, but I'll tell you from a transparency standpoint, it does matter, because then at least the public can see what's happening. Oh, they thought they could have proved this, and they're charge bargaining down and giving something away, but a lot of places won't do that because of how their data gets reported. They don't, the DA doesn't want to have to stand up in the next election and say it's true, we dismiss 70% of the charges that we file, and then explain that they do it via plea bargaining. But it depends. I mean, plenty of places they'll bring all of the charges up front and then bargain them away. But when it comes to the criminal justice system generally, but plea bargaining in particular, it's so hard to gather the numbers on these things, and the practices vary and the laws vary, as you know, from place to place. So what I'm trying to highlight in the book are sort of the themes that we see everywhere, even though they play out slightly differently in different courthouses and different states. But
I look forward to reading it.
Oh, thanks. Thank you.
Have there been any instances of judges, be they district court justices or judges, or all the way up to the Supreme Court, bemoaning the fact that they more or less have to, or generally have to agree to this plea bargain but expressing a dissatisfaction with the way the agreements are currently handled, some expression that they wish they could in some way alter these deals. So we haven't heard anything from the bench like we sometimes hear with mandatory minimums saying, I wish I could do something about this, but my hands are tied because this agreement is legally fine bad from a societal policy perspective.
Yeah, I'm so glad you asked that question because, so the question was about, do we hear judges complaining about the fact that their hands get tied by the plea bargains that are struck between prosecutors and defendants? Do we ever hear them complain to say, like, I wish I could do something else, but this is what the parties have come up with, and so on and so forth? Sometimes you hear judges say that, but the truth is they can't complain too loudly because judges don't have to accept plea bargains. They don't have to say, I accept this agreement and I think it's inappropriate. The court rules in most states, and definitely in the federal system, allow them to say, I don't like this bargain. But the only time that they tend to do that is when they think that the bargain is too lenient. So one high profile, maybe this is getting to be too old to use as an example, but one of the Enron defendants, he and his wife had struck a deal, and the trial court judge down in Texas said, this is not going to be a serious enough conviction, and I'm not going to be able to give enough punishment considering the harm that you did. So he rejected the plea bargain, and the parties went back and renegotiated. More often what you see are judges complaining that the prosecutor insisted that the defendant plead guilty to a charge with a mandatory minimum, and should they have done that or should they have not? There are a few published opinions where they say that. But the truth of the matter is, judges could say, I don't want to accept this plea bargain. They just tend not to. It's become very fashionable to blame prosecutors for all of the ills of the criminal justice system, but judges were imposing the trial penalty on defendants who insisted on going to trial for decades before plea bargaining became the norm. Judges didn't want to have to try cases because they felt like they were too busy and it took up too much of their time. I wish I could say that judges are the heroes in this story, but in fact, they've been a huge part of the problem. The Supreme Court, I think its plea bargaining cases are just an embarrassment. I cringe every time I have to teach them to my students as they violate basically everything that we know about the Due Process Clause and constitutional rights more generally. And I think the last thing that I'll say is, we've had this turn towards originalism in this country, where a lot of judges, especially judges appointed by Republican governors and presidents, have said that they want to adhere to the original understanding of the Constitution. If they did that, it's not so clear that plea bargaining would be allowed. There's some great scholarship on this by Albert Altshuler and John Langbein, where they trace the early plea bargaining cases sort of just before and just after the Civil War, where appellate court judges would find out what's going on and they would be like, what are you doing? You can't do this. The parties aren't supposed to negotiate over guilt or innocence, and it's not up to the prosecutor what sentence a defendant should be serving. They'd find out that there was a plea bargaining and they would reverse the conviction and send it back down to the trial. There were even some sort of skeptical US Supreme Court cases that didn't address the issue head on. Unfortunately, it wasn't until the 1970s when we'd sort of really become so dependent on plea bargaining that the Supreme Court finally had to confront the issue. And when they did, they were very clear that they were allowing plea bargaining because they didn't think that we had the capacity to try all of these cases. So in some ways, it's our obsession with dealing with all of our social problems through the criminal justice system and our unwillingness to pay for that obsession that sort of got us where we are today. It's a great question. I'm glad you asked it.
I think that you answered that question brilliantly, and but would add as a former criminal defense lawyer that I wonder whether the fact that most judges don't have any criminal law experience, or if they do, only from a prosecutorial point of view, also adds to this feeling that a plea bargaining is really some sort of, actual negotiation between two equal parties, and the judges should get out of the way and just bless, what was a fair process. And of course, only if you have had experience as a defense lawyer would you realize that that's not really an accurate depiction of what the plea bargaining state is. So that's my 2 cents on that one. But I actually have a question. And then I said there are criminal defense lawyers and people in the advocacy community who are deeply concerned that we have absolutely no challenges to the government cases at this point, and think that the only way to fix this is to break the system, to say plea bargaining shouldn't occur at all. And if we said that, our judicial system would grind to a halt, because there couldn't possibly be the number of cases that are charged now actually processed and go to trial, but that would be a good thing. That breaking the system would show, in fact, that the system is broken, that we are charging too many people with too many crimes, that the punishments are too large. Is that your fix? Do you have another fix? What are your thoughts on that?
It's not my fix for lots of reasons, including that I'm like a Burkean conservative. So the idea that we would break a system just gives me like the heebie-jeebies. But I'll also add, even though every time I sit down to talk about the criminal justice system, it's so easy to talk about how it's too harsh and it sweeps in too many people. The truth is, there are serious crimes that get committed, and I am somebody who thinks that a criminal conviction ought to be the end result of that and punishment. I don't support the idea of abolition or those sorts of things. Do we have too many laws? Yes. Do we punish people too much? Many times, yes. Should we ban plea bargaining? No. We've tried that before. It was tried in Alaska, it was tried in El Paso. It didn't work, it didn't stick. People bargained, or people got around it because it's actually better in individual cases oftentimes for everybody to have plea bargaining. In fact, some of the defense attorneys that I talked to, said they were complaining that academics are always saying, let's ban plea bargaining, and they're saying, don't they understand how I'm able to help my clients? I'm able to help my clients by negotiating a good deal from them, convincing the prosecutor that this defendant deserves a second chance. The problem with our country is when we have rigid rules, we want those rules to be harsh because we're much more concerned about people being treated too leniently than we are with people being treated too harshly. That's, I think, what we have to fix in the system. We have to come up with a way to individualize justice and still make it seem fair. I think the fixes are boring, unglamorous things like not making misdemeanor defendants show up for all of their court dates. We don't make civil litigants do that. It's because it's silly and nobody wants to do it and it doesn't make sense. That's not how you resolve a court case. I think it's by really curtailing when bail, when people can be forced to post bail to get out of jail. And frankly, it's about better informing the public. On my way here, I checked the news and some police chief was testifying in front of, I think, the New York State Legislature in Albany, insisting that the spike in gun crimes is because New York reformed its bail law. That's just a lie. Maybe he's not lying, maybe he's horribly uninformed, but every single person who's studied the spike in gun crime has shown that it has nothing to do with New York's new bail law. But we terrify the public into thinking that if we let people who were accused of crimes back out into the street, then they're just going to murder and kidnap and do all of these awful things. Part of, I think, what we have to do is we have to reset social expectations so that when something bad happens in this country, we try to figure out how to treat the root causes of that rather than saying what we need to do is lock more people in prison. Because don't get me wrong, some people should be in prison, but we're not gonna fix the problems that people care about through prison alone. So boring stuff like some more money for indigent defense, maybe, clearer guidelines about plea bargaining and more transparency about plea bargaining. It's prosecutors being very clear about when they're going to dismiss cases. It might even be instituting motions practice and discovery like we have in civil cases as well. But then also too, probably judges saying things like, we can't let everything be part of the plea bargaining process. You shouldn't be allowed to bargain away your right to discovery, your right to an appeal, whether your kid gets investigated for a crime. Plea bargains should be really narrowly focused, and they should be policed to make sure that they aren't unconscionable contracts. So a boring answer to a difficult question.
All right, so those are some of the solutions, which I think is a great note to end on. The book is Punishment Without Trial, Why Plea Bargaining is a Bad Deal. For the folks in the room, there are books available for sale at the back, and Carissa will be personalizing some of the books. And then for the folks online, you can click over to Barnes & Noble right now and get your copy. So please join me in giving Professor Hessick a round of applause.
Thank you very much.